Now, at this point, I would like to shift away from the employment laws that we've been focusing on and move into a discussion on labor law. And while labor law is related to employment law, and in fact, most people use those terms together, labor and employment, as do we, there is a significant difference between traditional labor law and employment law. And labor law is primarily governed by, at the private sector, the National Labor Relations Act, which is administered by the NLRB, or in the public sector by the Public Employment Relations Act, which is monitored and administered by Merck. And while most people think of either the NLRA or PARA primarily involved in the context of union organizing activities or affecting unionized workforces, while those are certainly areas of important concern, we will review the issues that also apply to non-unionized employers, because both PARA and the NLRA apply to both unionized and non-union workforces. First, with respect to organizing, it's also important to pay close attention to what's going on. You probably see it in the news, you probably hear it on the radio and whatnot, is organizing activity has increased dramatically. And that is something that we expect to continue. So we're going to talk a little bit about, what is going on, what to watch for, what you should do under certain circumstances. And then we're going to shift over to discussions outside of the union context. And if you're non-union and your employees are not interested in a union, why should you nevertheless be concerned with the obligations that these statutes place on you as the employer and the rights they give to your non-union employees? And so Cliff Hammond and I work pretty closely together on these issues, and I'm going to turn this over to Cliff to drill into some more of the detail.
Thanks, Mike. Yeah, my name's Cliff Hammond. I deal with a lot of these issues. Employment and labor do go together, but they're not exactly the same, like Mike said. And so I want to talk a little bit about really, what are you going to get out of this presentation here? Now, Mike, I don't have control of this slideshow, but if you go over to the next one, I wanted to really go over, so what are some of the signs that you're having labor activity? Because it could be a big deal, like Mike said, and we'll talk a little bit more in a couple of slides. There are some things you might not have noticed coming into this training if you haven't been in a unionized setting, whether it's in a public sector or private sector, that I want you to know about. These are little things that you probably haven't seen before. So if you see this out your window, giant crowds, maybe Lenin's out there, burning buildings, then you'll know there's a union. Okay, so now you know that. Now you know what to look for. But not always, it's not always going to be this dramatic. It could be. I mean, there could be a massive march in front of your building. But usually what will happen is, if you go to the next slide, Mike, because I don't have control of this, you'll see that it's usually a little bit more subtle. You have people that'll come up, they'll talk to your employees, they're going to get text numbers, they're going to be off. No union campaign is very successful if people know about it, because once you know about it, you're going to start educating your employees and employees start coming back to you. So it's usually clandestine until it's already either done, they walk away, or they file a petition to be unionized. So you have to be careful in what you do. There's a lot of laws, but I want you to know that most campaigns, the number one thing people always tell me when they get unionized is, oh, we had no idea. Of course you had no idea, because that's the goal, right? So we have complicated ways of doing this. We have social media, we have one-on-one meetings, home visits. Those are still going on. And I can't go to the next slide, but if we go to the next slide, you can take a look here. There's this place called the National Labor Relations Board. It's a very small agency. It's a skeleton crew, but they have immense power over both non-union and unionized facilities. And so the workforce that's unionized is very small, but the National Labor Relations Board, it actually has the, for public, for private employers has great latitude to make sure that your rules and your regulations and the way you treat your employees is being done under their law. And it's a different type of agency than you've dealt with. It's different than the EEOC. It's different than a court system. It's different than these other agencies like workers' compensation, because they have investigators, they have their own judges, they have their own quirky rules that you may not know about. We'll talk about that. For public employers, we have in the state of Michigan our own rules. So if you're a public employer, you are covered by Merck, and that's all employers. And again, they represent all employees, union and non-union, and there are rules that you have to follow if you're unionized. So it's just important to know there are differences between the two. From October of 2021 to March 2022, what we have noticed and what the statistics have shown is that unions have filed 57% more petitions. Why is that important? Because it demonstrates that even though COVID did tamp down a little bit of the organizing issues, it's significant. So you can see unions are getting more bold. They're coming out there, they're attracting employees. And claims filed by unions at the NLRB saying employers are violating the law have actually increased by 14% as well. Now, what that means is we're seeing dramatic changes. So if you take a look at this, we have 250 petitions actually filed at Starbucks. That's 250 different stores around the country. Now, there's probably 350,000 Starbucks, but either way, 54 have been organized already. Amazon actually have been facing unions for years. I mean, just millions of dollars put into it. And they finally won. They got a warehouse organized in New York. Google Fiber, which you put a lot of money into not having that. Even Home Depot has now had its first petition. So why is this happening? Well, polls are showing that people are more happy with unions than they used to be. In fact, 68% of those polled by Gallup last year showed that they were favorable, that they said, yeah, unions are okay. And that's a big change. At one point in time, they had a very negative feel. So the bottom line is, who cares? If you don't have a union and everybody loves who you are, why? What difference does it make, right? Well, let's talk about this. It actually does matter to you. So the law applies to everybody. The general counsel, who's the head attorney for the NLRB, has said that, you know what, we need to start looking at these non-union handbooks, because I think there's a lot of rules in there that are wrong. And the NLRB has very strict construction. And I want to give you some examples of things that the friends at the NLRB have found to be unlawful. Things such as you are prohibiting employees from lying. That is unlawful, according to the NLRB. How dare you tell people? Because in their belief, that would mean that a reasonable person would sit there and say, I don't think I can avoid telling my boss that I'm going to the union meeting tonight. If you just put lying by itself, that means that would inhibit my rights under the NLRB. Now, that's obviously crazy, but that is what they've taken at times. Here's some other fine rules that they've said are outlandish and wrong. Never publish or disclose the employer or any another's confidential or other proprietary information. Never publish or report on conversations that are meant to be private or internal to the employer. Sharing of overheard conversations at the work site with your coworkers, the public, or anyone outside the immediate work group is strictly prohibited. Confidential information is all information which its loss, undue use, or unauthorized disclosure could adversely affect the employer's interest, image, reputation, or compromise personal and private information of its members. A lot of employers would sit there and say, what's wrong with that? Well, the NLRB said you can't do it. Here's some more fun examples of things the NLRB has found to be unlawful. Disrespectful conduct or insubordination, including but not limited to refusing to follow orders from a supervisor or a designated representative. Unlawful, outrageous behavior, according to the NLRB. Okay, chronic resistance to proper work-related orders or discipline, even though not overt insubordination, will result in discipline. I mean, how are you going to run a business? Well, obviously, we've got to have a collaborative effort, because you can't tell people to stop being chronically resistant to discipline and work orders. Another one, do not make fun of, denigrate, or defame your coworkers, customers, franchisees, suppliers, the company, or our competitors. What do I do during the day? I mean, if I can't do that, obviously that's unlawful. Be respectful of others and the company. Oh no, you can't say that. That's unlawful according to the NLRB. And finally, here's a fun one. no defamatory, libelous, slanderous, or discriminatory comments about the company, its customers, or its competitors, its employees, or management. Nope, can't have that. That is unlawful according to this federal agency. So obviously, we take a look at this and we say, well, it's clear as day or it's muddy, right? Which one is it? Do you think it's muddy? Do you think it's clear as day? Actually, you could take some of those rules, you could reword it, we could work with you, we can make them lawful. But if you don't do it right and you're sloppy in the way you develop your work rules, and not even sloppy, you just use common sense of way people have done things for 80 years, this agency will come against you. Now, Merck is a little different. Merck generally, but not always, follows what the NLRB says. And they're not quite as tight on their review of the work rules as the private sector is, the NLRB. But there's a very big difference. Here in Michigan, we have right to work, where people don't have to pay dues to be part of the union in order to keep their job. They changed that, if you remember, a few years ago, and they have right to work. And the reason why is because the National Labor Relations Act that oversees relations between employees and their employers said that each state can do that. They have the right to do that. But wait, not so fast. That could change. Okay. And so let's go to the next slide here real quick. Let's watch out for some stuff, because there's this new law that's floating around Congress. And in a couple of weeks, there's going to be this election, I heard. And if at the federal level, there's some serious changes to the composition, by the way, of serious changes, I mean, the House stays exactly the same and the Senate gets one more vote, then you have a very likely chance that the PRO Act, which has been passed by the House already, but is sitting around, could get enacted. And it has a few things that could happen that are a little bit different. So the first thing would be, those work rules we just talked about, each one of those would have been a $50,000 fine for each one. Let's say you fired 4 or 5 people. That's $50,000 a piece. And that's not against the company only. That could be $50,000 against anybody who wrote that rule, anybody who enforced that rule, and anybody who knew about it and didn't do anything about having that rule in place. And if you do it twice, you could have $100,000. And if you do something real serious, it could be $100,000. That's a check from you if you're involved with that. So if you fire somebody for union activities, if you go out there, you do these things, there's a serious thing. Now, right now, there's no major penalties. There's no civil penalty. If you fire somebody, it's unlawful. You put them back to work. You give them their back pay. And there's no attorney's fees and all that you get from some of these other claims that we've talked about today. But this changes the game. Now, not only does it do that, it says you can't meet with your employees in a big meeting as an employer to tell them about the benefits of the company versus not the union, which we do now. That would be unlawful if you force people to go to those kind of meetings. It wouldn't allow you to lock employees out if there was ever a strike. So if somebody goes out on a strike, you can't lock them out. You can't even replace permanent replacements, which is sort of the check against it. So some major issues. Now, more importantly, to some of the things that we talked about today, it would preempt and exclude you from having certain types of agreements like collective acting. So basically it would outlaw arbitration. That's effectively what it's going to do. And if you want a class action prohibition, so you can't do a class action, you have to file a claim individually for wages or things like that, that would also be an unfair labor practice. What also would have a problem would be classifying people properly. We heard earlier how clear that is when Carl was talking earlier about misclassification issues. You have to be careful. If you misclassify somebody, that will be an unfair labor practice as an independent contractor as opposed to employee, and it could have some very serious fines that come with it, individual fines and some significant changes. So we just have to be very careful. We have to keep an eye out. Right now, the NLRB is doing some things to try to do all those, but without that massive hammer of a penalty. There would also be some changes to the way unions are operating. So I don't want to get into details if you're not organized, but I do want you to know that it's more than just unions. And that's the key here, is that the NLRB, like other agencies, are trying to look out for their law. And they're really, trying to make some changes in Congress to make it more relevant to everybody. So if you go to the next slide.
Yeah, and the next slide, what we're going to talk about is the DE&I, and Matt talked about it previously, but with respect to diversity, there's a issue of exactly how does diversity and the appropriate desires and needs for diversity in the workplace affect the current employment laws against discrimination and various affirmative action programs or whatnot. So we just wanted to hit the high points of what DEI is and how diversity in the workplace works. So Cliff, you can continue.
Yeah, and I don't want to take a lot of time because we could take a lot of time on this. We could take all day to talk about these issues, but I want to make sure people understand what they're talking about. The buzzword, as Matt said, DE&I, diversity, equity, and inclusion, is a significant part of business today. It is multi-million-dollar initiatives going across everybody's table, and we throw that around like we know what it means. And I know from having conversations, people do not know what that term means. What it is not is the same as the law for equal employment opportunity. And I want to make sure that's very clear to HR professionals, owners, managers, and people like that. The key here is you as an employer have several laws you're under. You have the Title VII of the Civil Rights Act is a federal law. It's a big daddy of them all about not discriminating against people based on race and gender and all those protected classifications we've talked about and you know about. And you have policies in your handbook, or you should have policies that talk about, we don't allow people to discriminate, we don't allow retaliation for bringing forward discrimination, and there will be consequences if people do that. And you have work rules on that. That's because we want to make sure that we comply with the federal law, as well as Michigan's law, which is very similar to the federal law that prohibits you from discriminating on things like height, weight, sex, sexual orientation. Those type of things are protected by law. That is not what DEI is. DEI is bigger. It includes, but is much broader. And it's a program that's talking about we want to diversify the thoughts, the people, and the initiatives that we have. We want to be an inclusive place to work. We want to go out and we want to reach out to people, and we want to make sure that they're part of our program, that we educate employees, and that we do more than what the law requires. Because the law, there's actually some cases out there that say that Title VII, the big federal anti-discrimination law we talked about, it is not a general civility code. That's exactly what the court said. It's not. It's not about being civil to people. Well, DEI is trying to say, actually, we should have a civility code. Actually, we should talk about that. And even if it's not illegal, we shouldn't worry about whether it's legal or not. We're trying to do the right thing. We're trying to get more from our employees. And it is a significant effort. It is tailored broadly to try to make sure employees have a culture change. It's a culture of inclusion, a culture of acceptance, not a culture of, hey, we'll do what the minimum is. And that's a very big difference for employers when I say, okay, so how do you want to do a DEI program? And they say, you know what, we want to do certain hiring practices. We want to do certain recruiting practices. We want to do certain educational practices on different types of non-discriminatory behavior, things that go beyond discriminating based on the legal definition, but trying to stop words, harmful actions, maybe some sort of prejudice that you might not know about that might not be unlawful, but it's very significant, and we want to put money and time and effort, and we want to make sure our employees feel included. It is different. It's generally more different, and you won't even have it in your handbook. You'll have trainings. You have to go about a deliberative process. But why I tell you that is the same law that protects employees from being discriminated against based on prejudice, racism, and sexism and ageism also protects employees from not being hired, from not being promoted, because you had good intentions under a diversity program or a DEI program, and you went and made quotas. Say we want to have minorities in X positions. That actually could get you in trouble with the EEOC as well. So while we have some very good DE&I programs, we have very good DE&I instructors, as an employer, you still have to safeguard against very energetic, positive thinking people coming in to help you that may not understand that the EEOC, the federal agency that oversees discrimination, could find that you're actually discriminating against some people that were not the group you were trying to help. So for instance, if you're trying to get more diversity into your workplace and you say, you know what, we're not going to hire, I'm sorry, we can't hire you because we're really trying to hire people from minority classifications, that person could bring a lawsuit against you because they'll say, I applaud your efforts, but I'm qualified. And the only reason why you didn't hire me is my fill in the blank minority status. So you have to be careful, which runs to the next point, which is an affirmative action program. What is it? Well, affirmative action programs are great programs. The Department of Labor, the EEOC, they all have different programs there. In fact, if you're a federal contractor for over $50,000, you have to have an affirmative action program in place. What an affirmative action program is, you're going to go out there and you're going to look at ways to look at the market, figure out how are we going to get better at certain areas, identify problems and shortages in certain work areas, see what the market is, what the minority categories are that you want to identify, and put some educational components, some document record keeping together, and make sure that you're doing everything you can to make sure that you have a well-represented workforce. It's a great initiative, but the EEOC will tell you point blank when they talk about it, but beware. Number one, it's a very difficult process. It's very fact intensive. It's very document intensive, and you have to do it every year, and you have to do it right, because if you set aside quotas, if you do it in the wrong way, you don't hire people based on their race, it's still unlawful. Why do people get into an affirmative action programs that maybe they're allowed to do some things that you couldn't do in other places? Well, sometimes it's because they get sued for race discrimination and they're required under a court order. You can do a voluntary program, but it has to be set up properly, and you have to make sure you're balancing between wanting to get this diverse workforce. You want to be inclusive, but you can't be unlawful. It is a very tight dance, and we can't just go over all this in one day. We could go over probably for weeks about how it has to be done. How do you create one? It takes a lot of time. It takes a lot of effort, a lot of paperwork, and a lot of research, and it costs money. And Mike and I talk about this all the time. These are not easy programs to do right, but they are easy to get wrong. And it's very important to understand your intentions are not what is being looked at. It's not your intention, it's how it's executed. So what are some of the consideration, and what happens if you get it wrong? Well, you can get sued, right? You can get sued by people or a class of people under a discrimination lawsuit. And again, if you do it right, you can get sued no matter what, but you have good defenses. So you want to take your time. And when you talk to experts, when you talk to consultants, when you bring in your DEI and diversity, there's a difference between saying, I'm going to hire this minority group only, and saying, you know what I'm going to do? I'm going to expand the group of people that I'm going to apply to. I'm going to go to some conventions. I'm going to go to some interest groups. I'm going to go start putting applications, or, putting my process for who I select and who I market to groups that are more diverse. That's more appropriate. Trying to go out and get a more diverse pool of people than it is saying, well, I don't care where the people come from. I'm just going to hire this group, older people, all right, or people of a certain religion. It might be great, but it's not what you're trying to do. You have to be very careful when you're setting together a diversity program, a DEI program, and an EEO legal requirement under the affirmative action program. So it is complicated, and some people think it's easy. It's not, and you can get in trouble quickly if you don't do it. Some places don't care. Some places say, whatever, sue me. I'm trying to do the right thing, and it's worth it. I'm a martyr. That's fine. I mean, that's okay. Just know it going in that you are subjecting yourself to potential problems. So, Mike, I know you and I have talked about this a lot. I mean, from my standpoint, if we have questions on that, we can talk about it, but it's probably best to talk about it from your standpoint. What type of employer are you? What are you trying to do? Where are you located? Things like that. But I know that we had a lot of questions that were in the chat box that, were about the wage and hour stuff more than it was about this. But I think we can probably address a lot of those if we haven't already, Mike. With respect to the wages and hours.
Yeah, what I'm thinking, Cliff, is that we had scheduled this to end at 11:30, and it's a touch past that at the moment. So what I'm thinking we will do is that we will take all of the questions that we have not yet gotten to, and there's some overreaching issues. There's some coverage issues, which employers are covered. There's some employee eligibility issues, which employees are excluded from being eligible for certain benefits and whatnot. So I think what we'll do as a group is we will put answers to the general questions and post them. And Kim, I think you're still with us. You had talked about this will be available after today. I'm not sure exactly when for the video and whatnot. So I think we'll post that. And then if hopefully that'll answer most, if not all, of the questions that we did not get to. And if not, feel free to reach out to anybody that presented, or me, or Carl, or Cliff, or anybody that you're comfortable with is fine. If you have any specific questions, some of these may be specific to a particular business or a particular industry. If it's a case sensitive or a specific issue, you might need to talk to who your normal attorney is, whether it's inside Foster Swift or not. But I think that would be the most efficient way to do it. So with that, I would just like to thank everybody for being with us this morning. I think this was a great discussion. Hopefully you found it helpful. And again, we will try to get all of your remaining questions answered. If any of the presenters have anything else, or Kim, if you have any final comments, please let us know.
Well, Mike, before we go, I did want to just touch base on a common theme I saw in some of the questions, and it was, what if I have, a person who works 10 hours a week or 20 hours a week under the new changes to the Workforce Opportunity Wage Act? And the answer is, that person is going to be covered under the new, sick leave law. That person is going to be covered because it's going to include everybody. I mean, no matter who you are, if you're working, you have to accrue time. The good news is you're not going to accrue a lot of time because you're not working a lot. So it's by hour, right? But it's still going to cover you all. And there's only a few exceptions. And I think Tony did a good job of going through all that. But the reality is this is everybody. And when you're trying to figure out if you've got 10 employees or not, they're saying you even include your temps that you use from your temporary service company. So if you're using temps, they're doing that. That's the key. The key is this is supposed to include everybody. And I don't see an exclusion for minors. So if you're using minors, right, people under 16, they may be entitled to it too, based on my read of the statute. And again, we haven't any court interpret it. We only have a document in front of us, but right now, that is an extremely broad definition. So just know this is not a small thing. The leave is going to be for everybody, whether you're small or large, and that small definition is even smaller than you think if you're using temporary employees.